Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today's Tuesday, 10 a.m. here on the Bottled Business Sense Show. Welcome back. It's been a little bit since we've been here, but excited to get back in the swing of things. If you are watching for the first time, welcome. If you are a returning viewer, then you know how the show goes, and we really are excited to talk about today's subject matter. But before we do that, you can always go back to previous episodes that we've published in the past on various different platforms. You can see that on the bottom of the screen there. We have iTunes, Facebook, Twitter, LinkedIn, and YouTube. And so just go ahead and type in the keyword Bottle Business Sense Show, and you'll find a plethora of all of our different episodes we've done over the past 5, now coming up on 6 years. So my name is Rick Moscoso. I am one of your co-hosts. We have Bill Bernard there on the other side, and Bill is going to talk about a subject matter centered around estate planning, and specifically why estate documents are important to maintain, and they're not just something that you just fill out and let it go. And so Bill is going to talk a little bit more in specific about that. So let's welcome Mr. Bernard onto the live stream.
Yes, sir. I see we have some new intro music on the show, so I'm very pleased about that.
Thought you'd be happy about that.
Yeah, I needed something to spice me up there and get me started. So I'm happy about that. So we're going to talk today about estate documents and why you just don't have an estate plan done, and then that's the end of it. Now, this presumes, of course, that you have an estate plan done, and God knows that that's the first step. You have to have an estate plan, or you should have an estate plan, and you see the appropriate lawyer, and you have that drawn up. Once that's done, it's not a finished process by any means. Doesn't necessarily mean you have to sink a whole lot of time, effort, and money into it, but you should review it. And there are certain things that happen when you review your estate plan. Let's talk generally about how it differs from when you first draft the estate plan. For example, you may have more children. You may have the acquisition of additional assets. You may have a fallout with friends or other beneficiaries. You may have a marital dispute, and there may be even changes in the estate law where you live, in the jurisdiction you live in, all requiring a review of your relevant documentation. And I would suggest you do this once a year, maybe at the very latest, once every 18 months. So let's generally talk about a subject that I hate before we get into specifics about amending a trust, and that is amending a will. Some of you just have wills. I'm not going to get into a long dissertation about why they stink when they stand by themselves, but nevertheless, some people have them, and I think I'd be remiss if I didn't at least mention the fact that you can amend a will by drafting what is called a codicil, and codicils are best kept for minor changes. If you're making substantial changes, obviously, you're going to want to scrap your old will and draft an entirely new one. Since there are formalities for executing a will, the same as there would be for a codicil, you're going to want to have witnesses. You're going to want to make sure that any mistakes are reviewed by an attorney Make sure that your new will, if you do a new will rather than just a codicil, is dated and includes a sentence stating that it revokes the old will. Okay, that's about essentially what I'm going to say about a will. So a codicil would be an amendment if you're going to make substantial changes to the will, and you'll see some substantial changes that we talk about with reference to a trust in a second. Well, then, if there's substantial changes, you're going to want to revoke the old will. Make sure you indicate that in the new will that any old wills are revoked, and then what I would suggest is to trash it. But of course, some people want to keep it because they feel that it will avoid arguments over any undue influence should that issue ever arise when you pass. In other words, it's evidence of what your intent was at one time, but is no longer. And candidly, my preference is just to destroy the old documentation and go with the new one. Let anybody challenging your estate come up with whatever they have to do to prove that there was some undue influence over you when you made the new will. Let's talk about trusts. Trusts, amending trust. It requires less formalities when you want to change or add beneficiaries, change the disposition of assets in the trust, or when you want to change your trustees. Amending a trust to add a property is only required if the property is going to be given to a different beneficiary than that already named in the trust. If you have it set up to where any additional properties will simply be dispersed to the original beneficiaries in the trust, the way the property already in the trust is to be dispersed, then you have no problem. If you're going to change how a new property is going to be dispersed to a different beneficiary, then you may want to do an amendment. Remember, a properly worded trust will always allow you to add property after the trust is drafted without any additional amendments. Again, barring some exceptions that I just mentioned, a whole totally new beneficiary that wasn't in the original trust to begin with. Generally speaking, an amendment to a trust must explain the changes. This is important, must explain the changes, specify additions or deletions, and be signed and dated. And please, there are people that don't indicate this, but I do, have that amendment notarized. Excuse me. Don't know why I'm getting a call I shouldn't get during the show, but I did, even though the phone was supposedly on mute. So anyway, make sure that you have the amendment to the trust notarized, and make sure, unlike a will, you shouldn't revoke an old trust and make a new one. You're only going to do that under certain circumstances, which we'll talk about in a minute. If you want to make substantial changes to your trust instead of just these minor amendments that we just spoke about, well, then you do what's called you restate the trust. So it's a restatement of your entire trust because you want basically the framework and the foundation kept intact, but you're going to make some substantial changes as opposed to just a few minor changes. So rather than an amendment, you restate the trust, and you must understand and realize that by restating the trust, while you're making substantial amendments to the trust, you are not required to refund the trust. In other words, your properties that are in the original trust and your assets, I should say, that are all placed in your original trust are automatically included in your restatement. You don't need to go through the process of refunding the restated trust. Okay, that's important.
Bill, can you give us an example? Can you give us an example of why somebody would restate a trust?
Well, because of some substantial changes. Excuse me. For example, let's say a lot of time has passed, and in fact, I just restated my trust not more than a week ago. So I restated my trust because I wanted to change beneficiaries. I wanted to change the distribution of assets. I wanted to change the successor trustees in my trust. So because I had substantial changes that would affect a number of different people, including the trustees, the successor trustees, rather than doing an individual amendment for each one of those, And by the time I state the specifics and what's being revoked, what's being added, and get those all properly notarized, I might as well just do a restatement and make the substantial changes that I want over a number of different articles within the trust. So again, if you're going to make changes that are more than just simple changes, for example, I want to change a trustee. A successor trustee has died, so I want to name a new one. That's a very simple amendment. But if you want to change a number of different successor trustees because there's been a change in their lives or because one or more of them have passed away, and in addition, you want to specify certain assets that were going to be split up among a number of different beneficiaries, and now you want to give some to a specific beneficiary instead, or you want to change the kinds of assets that you're going to be putting in your trust that over time maybe you didn't include initially. For example, maybe you want to change an IRA that typically doesn't go into a trust that has its own beneficiary attached. Now you want to make the trust a beneficiary for some reason. Well, then now you're making substantial changes to your trust, and so you're going to want to restate it. It's a lot easier to do that. And frankly, when you get into the cost involved, you might as well just restate it because the individual amendments are going to mount up. Remember, when you're doing something individually, typically you charge more on the dollar than you would if you did something that's all inclusive and that might be easier to do because of the program that the attorney might be using. You can just interdisperse certain changes in a restated trust according to the client's desires. So there are a number of different factors that go into this. You need to speak to your attorney. He or she will tell you what they think is more appropriate based on what you want to change, what you want to do. So remember, you should never detach a page from your trust or type new information over it and put it back in the original document. This invites a plethora of legal challenges, which you want to avoid at all costs. So we've talked about amending a will by way of a codicil. We've talked about amending a trust by way of making minor changes. We've talked about restating a trust where you're making substantial changes. Now, what about redoing and what about making an entire new trust? It's not a restatement. It's not an amendment. You're basically revoking the old trust and making a new one. Let me give you some circumstances under which that might occur. And again, it's always important to speak to your lawyer about this to see what is the preferential way to go about this. Depending on what your goals are, your attorney is going to make recommendations to you. And you think about it, you decide, and you take into account what's involved and go forward based on that recommendation. So 4 reasons initially come to mind as to why a settlor or a creator of a trust might want a new trust rather than a restatement. Remember, a restatement is you're making substantial changes to the trust, but the basic framework stays in place. Number 1, the settlor, and I'm going to refer to the person as a settlor. He's the creator or the trustor, all the same. Settlor, creator, trustor, that's the person who's making the trust, or persons, if there's more than one. The settlor may not wish for the trust beneficiaries to receive copies of prior amendments to the trust. As a matter of law, when a settlor dies, beneficiaries and heirs of the deceased settlor are all entitled to a copy of the original trust, including all amendments that were made to the trust. Maybe you've decided to make some substantial changes to critical beneficiaries who you feel might have a dispute with one another or try to call into question the validity of your new trust if they were able to see the old amendments and the old trust. So you may want to just not have a restatement or have amendments attached to an original trust. You may want to redo a whole new trust, revoke the old trust, get rid of it, trash it, and now when you pass, you've got only the new trust that are going to the beneficiaries, And again, if there's going to be any dispute or challenge to your estate based on some legal claim, it's going to be presumably a lot more difficult without those old documents in play to quarrel about. Second, the settlor may not wish to leave open the possibility that the most recent amendment, which even might be a recent restatement instead of an amendment, could be destroyed by a dissatisfied beneficiary. That is, someone might wish to discard the most recent amendment in order to proceed with an earlier version of the trust by saying that the amendment was the result of undue influence, for example. So rather than have that old trust out there as a way to come back to and claim to be valid without the amendment, you just revoke everything again, trash it, create a new trust. Titling assets over into a new trust with a new name and a new creation date, this would require retitling, cuts off that possibility to challenge whatever was in the prior trust, because now you're retitling properties into the and assets into the new trust. You have a new creation date, and that sets the bar for what can or cannot be challenged. The old stuff is gone. Third, with a joint trust, say one settled by a married couple, the surviving spouse might decide to transfer her share into a new trust in the survivor's name alone, in her name alone. Okay, so the surviving spouse may or may not be able to make amendments to the provision of the trust after the first spouse dies. The first spouse dies, that portion of the trust is now irrevocable. The assets go to the new spouse, and certain assets that the new spouse has may, in her view, she may wish to remove those from the joint trust and put it in a new trust for the benefit of her specific children, for example, rather than stepchildren. That may not have been taken care of in the original trust. Now the first spouse dies, the second spouse has the assets, and she may decide, hey, I'm going to amend a portion of the trust in terms of the assets that I still have that were not transferred to me by my spouse, his share. Now I have my share of the assets sitting there with his in the remaining part of the trust. I want to put those portion of those assets given to certain people. So I'm going to make a new trust utilizing those assets only, my share of the community property, for example, and I'm going to leave it to my original children, not to be shared with any stepchildren, because that wasn't taken care of in the original trust that was done between my partner and myself. Very important stuff. And fourth, and finally, community property assets and separate property rights of one spouse in a joint trust may be transmuted or changed into the other spouse's sole and separate property when the trust is terminated and assets transferred into a single settlor trust. You may want to transmute property. This is often done, for example, when you want to have a spouse qualify to receive Medi-Cal. And so you have to remove assets from that person's name, put the assets into your name. Now the other spouse has less assets to deal with and may qualify for Medi-Cal. So when you want to transfer or transmute property from community property into separate property ownership, or transfer it from one spouse to another, this might require a new trust to be drawn up, because now you have assets that are in a certain person's name only, and those assets have to be disposed of and are not in the same title that they were in when they were in the original trust that you had formulated with you and your partner. So these are intricate kind of things that you need to discuss with your lawyer. I touch upon these because I want to emphasize the distinction between amendments, restatements, and revoking and completing a whole new trust, and some of the examples that are involved. The examples I just gave you would be really good examples of revoking and redoing a whole new trust, starting with a new creation date and retitling the assets. If you want to do a restatement, you're talking about substantial changes to the trust, but not necessarily dealing or destroying or doing away with the specific foundation of the trust. You still have the basic foundation, but you may be moving stuff around to different beneficiaries, maybe moving trustees around, successor trustees, that sort of thing. And when you're getting involved to substantial changes in that regard, you're going to want to do a restatement. Maybe the law has changed. So now you're going to have to do a restatement using the same assets and same beneficiaries, but complying with the new law. On the other hand, an amendment, which is the first thing we discussed, might be a very minor change. You just want to change one beneficiary, or you want to change one successor trustee, that sort of thing. But keep in mind what you want your beneficiaries to find out or not find out is still alive when you do a restatement or an amendment. That only ceases when you do a complete new trust. If you want your beneficiaries only to see the new trust, then that's what they will see if you revoke the old stuff and do a new trust. So again, all stuff that you want to discuss with your lawyer, and he or she will advise you appropriately. I will trust in that, if you'll forgive my pun. So that's essentially it. These documents need to be reviewed again when things change, people change, circumstances change, times change, laws change. Things affect your estate planning documents that you may not realize up front, but you need to have these discussions with your lawyer. And again, my suggestion would be to review these documents once a year, at the maximum once every 18 months. And that should do it, Rick. I hope that should, give people the general information you need to seek out your lawyer and have your estate planning documents reviewed. Remember, there is no exception for having a lawyer do this, in my opinion. And there is no excuse for not having a proper estate plan in place, because without that, this show is meaningless. You first have to have the estate plan to be able to have it reviewed, right? So remember, this is all necessary stuff. It's all stuff to benefit you, and it's free, and it's foundational. Don't take what I said to heart with regard to your specific circumstance. These are generalities that you need to explore with your lawyer based on your specific set of circumstances, which only he or she will be aware of. Okay?
That's great. I appreciate it, Bill. As always, sharing your expertise is amazing. I learned every episode, so I appreciate you doing that. I'm sure
Thanks,
our viewers do the same. Folks, if you came in late and you want to watch the replay, of course, we have this on all of our digital platforms, Facebook and YouTube. If you want to watch the video, it will be in iTunes about 24 hours from now. So if you are more of an audio podcast type of learner, then of course you can listen to that on iTunes in about 24 hours. So
explain that, Rick, would you, for iTunes, and for people who may not, I don't mean to cast any aspersions out there. I don't know who knows specifically about, I don't even know all about iTunes. So maybe you can just kind of touch base on that, Rick.
Sure. iTunes recently changed their name. Well, not really their name, but the name of the platform where they do the podcast, the audio podcast. It's now called iTunes Podcasts. And so if you're on a desktop or if you're on your smartphone, you can download the iTunes app or iTunes Podcast app, and then subscribe to Bottled Business Sense Show, or Bottled Business Sense Show Live is what we are on iTunes, and subscribe to that channel, and then you'll get automatically updated when we do post a new episode or audio episode to that. So that would be great. We have a pretty big following, so we would welcome new followers, and if you would be so kind to just drop us a comment, do a review for us, and then subscribe to our channel. That would be great, because we want to grow this community, share as much information, free information, as we can in regards to this channel. And we have fun doing it, and it's part of the enjoyment of live streaming is having the ability to share this information to you for free.
And if you guys out there have information, you have a profession that can supply free information, general information to provide a footing or a foundation for people to springboard off of and then find out more about according to what their own specific circumstances are. Think about a show to do on YouTube. I have a potential client calling me today who watched one of our shows, who wants to talk about a cohabitation agreement. Two people living together that don't have community property rights, and they want to talk about a transmutation agreement in order to plan their estate ahead, and what that might turn into and how it might develop. So we have we do any kind of contract you can imagine, whether it's an estate planning contract, an employment contract, or a formation of some sort of a business entity, a contract. All founded in contracts, all things that can be utilized by anyone in business or any individual. So think about what you might have to offer, and do something like that if you have a mind to. The community, I'm sure, will appreciate it, and you'll be helping people at the same time.
Yeah, absolutely. If you have some subject matter you like to hear in the show, go ahead and drop it in the comment, whether you're on Facebook or YouTube. And you can always send us an email at bottledbusinessshow@gmail.com. And
I'm assuming they can, if you want, contact Rick. And obviously Rick sells his services. And if you need help with something like that, am I speaking out of turn, Rick, or would you be happy to help somebody set up a show and do a show?
Oh, sure. Yeah, that's what I do, and I love doing it. I have a lot of clients who are transitioning from since they're working at home and they want to share their message, whether it's a live stream like what we're doing here or an audio podcast to iTunes or both. I'd be happy to help them out.
And how do they get a hold of you, Rick?
You can reach me at rick@captivate365.com. So send me an email if you have any questions, and we can strike up a conversation.
Okay, and we go see you guys next time, where we will be talking about some rules that are necessary to think about when you're thinking about asset protection planning. I've had a lot of calls recently on asset protection planning, and I have a thought as to why that is, which I don't really need to discuss here. But a lot of people have misconceptions about when and why and how you do estate planning. So I want to give some touch-up reminders about that. And again, remember, these are general rules that you use as a springboard. You then go see your own lawyer and make sure he or she is aware of your specific set of circumstances in order to give you the proper advice. Okay?
That's right. So we'll see you folks back here in 2 weeks on April 20th, I believe it is, Tuesday at 10 a.m. And thanks for joining us today.
Take care, everybody. Have a good week.